Okay, let's unpack this. Imagine you've got this pile of really important legal documents, right? Supreme Court rulings, historical stuff, dissents. How do you quickly find what really matters? Cut through all the legal jargon. That's what we try to do here on the deep dive. Today, we're diving into a brand new Supreme Court decision. It's Trump v. CISO, Inc. Just decided this week, June 27th, 2025. Now, it sounds super technical, I know, but trust me, this ruling. It has huge implications for how courts can check executive power. And importantly, what it means for you if you disagree with something the government does. We'll explore what the court actually decided, the history behind it, and why some justices are pretty worried this changes the whole balance of power game.
Yeah, and what's really fascinating here, I think, is that the case wasn't even about whether President Trump's executive order, that's EO 14160, the one about protecting the meaning and value of American citizenship, was actually constitutional. Remember, that order was trying to redefine birthright citizenship. But the court didn't touch that. Instead, they zoomed in entirely on a procedural point. Do federal courts have the power to issue these things called universal injunctions? You know, those big sweeping orders that stop the government from applying a policy to everyone, not just the folks who sued.
Right, okay, so let's set the scene a bit more. What exactly was this executive order trying to achieve, and who pushed back against it?
Well, the EO essentially tried to lay out situations where someone born in the U.S. might not automatically be a citizen. It was a direct challenge to how we've usually understood birthright citizenship. And the challenge came from a really broad coalition. You had individuals, including pregnant women, worried about their children's status. You had immigrants' rights groups with thousands of members. And interestingly, a group of 22 states, plus D.C. and San Francisco. A really diverse set of plaintiffs.
And initially, what did the lower courts grant them? What kind of order?
In each case, the district courts went big. They issued what we're calling a universal injunction.
Right.
Basically, they told the executive branch, you cannot apply this EO to anyone, anywhere in the country, not just the people in the courtroom. It was a nationwide stop sign.
Okay, here's where it gets really interesting, like you said. The Supreme Court sidestepped the main event, the constitutionality of the EO itself, whether it messed with the 14th Amendment's citizenship clause. So, if not that, what was the precise legal question they tackled?
Yeah, they were very explicit about not ruling on the EO's substance. The court stated clearly they weren't addressing the constitutional questions or the Nationality Act. Instead, the absolute core issue was, does the Judiciary Act of 1789 give federal courts the equitable authority to issue these universal injunctions? Equity, is that traditional power courts have to issue fair remedies like injunctions beyond just money damages. So fundamentally, it was a question about the scope of judicial power. What tools do judges actually have in their toolbox based on history?
And the answer in a 6-3 split was basically no, limiting these universal injunctions. What was the majority's reasoning? Where did they dig for that answer?
The majority opinion, Justice Barrett wrote it, said these universal injunctions likely exceed the equitable authority that Congress has given to federal courts, end quote. Their whole argument really rests on that Judiciary Act of 1789. Congress gave courts equity power, yes, but the majority says that power is limited to the kinds of remedies that courts of equity traditionally used back when the country was founded. So the key idea is, if it wasn't a recognized power back then, it's probably not legit now, even if things feel different today.
So they went digging in the history books, looking at old English courts and early American practice. What did they find, or maybe not find?
Exactly. They looked back and concluded that these universal injunctions just aren't sufficiently analogous to anything courts of equity were doing in England around the founding. And they said early U.S. courts didn't really do anything different either. Remedies tended to be party-specific, meaning the court order only helped the people actually in the lawsuit. They even pointed to an older case, Scott v. Donald from 1897, where the court refused to give broader relief, even though it was asked for. Relief was just for the plaintiff.
Okay, so if they weren't around at the founding, when did these universal injunctions start popping up in federal courts then?
That's a good question. The court itself noted they really didn't become a thing until, quote, sometime in the 20th century. They mentioned a 1963 case, Roots v. Baldor Electric Company, as maybe the first one, though some debate that. But even after that, they were pretty rare until maybe the early 2000s. Since then, their use has definitely picked up speed. One study counted about 127 of them between 1963 and 2023, so a relatively modern phenomenon in legal terms.
Now, what about the counterargument? Didn't proponents say there was a historical parallel, something called a Bill of Peace? How did the majority handle that?
They did address that, yeah. But they rejected the analogy pretty firmly. They said, look, bills of peace were different. They dealt with, like, small and cohesive groups, and the court's decision bound everyone in that specific group, present or not. And crucially, the majority argued that the Bill of Peace actually evolved into something we have today, the modern class action lawsuit, governed by Rule 23 of the Federal Rules of Civil Procedure. So their view is that universal injunctions try to do an end run around the strict rules and protections built into class actions. It's like letting courts create de facto class actions at will without the safeguards.
Okay, so if universal injunctions are mostly out, what kind of relief can courts still grant? They talked about complete relief. What does that mean in this context?
Right, they drew a distinction. Complete relief isn't the same as universal relief. Complete relief means giving the plaintiffs who are actually in court everything they're entitled to, full stop. So, for example, stopping the EO from being applied to the child of that pregnant woman who sued, that gives her complete relief. But extending that protection to all other babies nationwide doesn't make her relief any more complete. See the difference? Interestingly, they punted on the state's argument. The states claimed they needed a universal injunction for their complete relief because of administrative nightmares, kids crossing state lines, etc. The court sent that specific question back to the lower courts to figure out.
Were there policy arguments flying around too? Practical reasons for or against these injunctions?
Oh, absolutely. Both sides had strong points there. The respondents, the groups challenging the EO, argued that sometimes universal injunctions are the only practical way to quickly protect vulnerable groups, ensure everyone's treated the same, and avoid endless scattered lawsuits. The government, on the other hand, argued they encourage forum shopping. Plaintiffs looking for one friendly judge to issue a nationwide order. They also said it's unfair because the government has to win every case, while plaintiffs only need to win one, and that it leads to rushed, poorly informed decisions on major policies. But in the end, the majority basically said, interesting arguments, but irrelevant. For them, the deciding factor was history, or the lack thereof. They just didn't see a founding-era precedent.
Makes sense from their perspective. Now, there are also concurring opinions, right? Justices agreeing with the outcome, but maybe adding their own thoughts.
Yes, a few. Justice Thomas, joined by Justice Gorsuch, wrote separately just to really hammer home the historical point. He strongly agreed that the 1789 Act didn't allow for universal injunctions and that complete relief doesn't stretch that far.
And Justice Alito, with Justice Thomas again, flagged another potential issue.
He did. Justice Alito focused on something called third-party standing. That's the idea of one party suing to protect someone else's rights. He worried that if states can easily sue on behalf of their residents and get broad relief that way, it might kind of sneak around this ruling. Like, could states effectively get universal-ish relief for their citizens even if individuals couldn't? It raises questions about future cases brought by states.
Interesting wrinkle. What about Justice Kavanaugh? He had a different take.
Justice Kavanaugh offered a slightly different perspective. He pointed out that plaintiffs aren't left totally without options for broad relief. He specifically mentioned class actions under Rule 23b, too. That rule is designed for cases seeking injunctions, not money, and can result in very broad relief, statewide, maybe even nationwide. He also noted that the Administrative Procedure Act allows courts to set aside unlawful agency rules entirely. And he made a broader point about the Supreme Court's own role. He argued the court itself often has to step in quickly on major new laws or executive actions to provide clarity and avoid legal chaos across the country. He thinks the court needs to be ready to take these big cases fast to ensure uniformity.
Okay, so that's the majority and the concurrences. But this was a 6-3 decision. The dissenters, led by Justice Sotomayor, joined by Justices Kagan and Jackson, had a very different and quite strong reaction. What was their main point?
Oh, absolutely. The dissent, especially Justice Sotomayor's opinion, didn't mince words. They started from a completely different place. They argued, quite forcefully, that President Trump's executive order itself was patently unlawful and unquestionably unconstitutional. Full stop. They went through the whole history, English common law, the 14th Amendment overturning Dred Scott, the Wong Kim Ark case confirming birthright citizenship, the Nationality Act, even past government opinion saying you can't just deny birthright citizenship like this.
So their starting point was the policy itself is clearly illegal. And from there, they argued that stopping the government from doing something illegal can't possibly harm the government.
Precisely. Justice Sotomayor basically said it defies logic to argue that keeping the centuries-old understanding of citizenship going for a bit longer while courts sort things out would cause irreparable injury to the government. How, she asked, can ordering the government to follow what the law already requires be considered harmful?
And the dissenters didn't buy the majority's historical argument about injunctions either, did they?
Not at all. They accused the majority of freezing equity in amber. They argued that equity, by its very nature, is flexible and designed to adapt to new situations. They pointed to older cases like Pierce v. Society Sisters in 1925 or West Virginia v. Barnett in 1943, where they say the court did approve broad injunctions protecting more than just the named plaintiffs. Their view was that broad relief to benefit non-parties actually does have deep roots in equity's history, contrary to the majority's narrow reading.
What about the state's practical arguments? The administrative burden, the kids moving between states. Did the dissent think a universal injunction was necessary for the state's complete relief?
Yes, they absolutely did. The dissenters agreed with the lower courts that, practically speaking, only a universal injunction could give the states complete relief. They talked about the cross-border flow of children and how impossible it would be for states to manage benefits programs if they constantly had to figure out who was covered by which court order based on where a child was born or currently lived. It would create an unworkable patchwork. They found the government's suggestions for narrower fixes to be, frankly, unworkable on their face, and probably conflicting with other federal laws about things like Social Security numbers.
And Justice Jackson wrote separately, too, with a particularly stark warning, calling the decision an existential threat to the rule of law. What was her reasoning there? That sounds serious.
It's a very strong statement. Justice Jackson framed it as a separation of powers issue. She argued the majority's ruling essentially gives the executive branch a green light to engage in unlawful behavior. How? By letting them violate the Constitution or laws regarding anyone who hasn't managed to sue and get a specific court order yet. She feared it creates a zone of lawlessness, especially impacting vulnerable people who might lack the resources or knowledge to sue quickly. For her, universal injunctions aren't some weird anomaly. They're a necessary tool for courts to actually enforce the Constitution and make sure the government follows the law for everyone, not just for the lucky few who get to court first. Limiting that power, in her view, fundamentally weakens the judiciary's role.
So, if universal injunctions are now much harder to get, what's left for groups trying to challenge these big nationwide policies? The dissent mentioned class actions, but had reservations.
Exactly. The dissent acknowledged that, yes, Rule 23b2, class actions remain an option for seeking broad injunctive relief, and they can result in nationwide orders. But, they emphasized, it's not a perfect substitute. Why? Because getting a class certified can be difficult and time-consuming. It often involves more legal hurdles, higher cost, and potential delays. And they pointed out, kind of tellingly, that the government itself, in this very case, refused to agree that a class action could even be certified to challenge the EO. The government made it clear it would fight class certification using all the barriers Rule 23 provides. So, yes, class actions are there, but the dissenters worry it might not be enough or fast enough in many situations.
Wow. Okay, that really was a deep dive. This decision clearly redraws some lines between the courts and the president. You've got the majority emphasizing historical limits on judicial power, aiming for precision, and then the dissent sounding a real alarm about potentially letting the executive off the hook and making it harder to uphold basic rights nationwide.
It definitely raises big questions going forward, doesn't it? How will challenges to major federal actions play out now? Will we see a surge in complex class action fights? Or will we end up with that legal patchwork across the country that worried some of the justices, where your rights depend on which court district you happen to be in?
So for you, the listener, the big takeaway is this. SCOTUS didn't rule on the citizenship EO itself, but it did significantly restrict the power of federal courts to issue those broad nationwide injunctions. This forces people challenging government actions and the courts hearing those challenges to look at different routes like class actions, which might be slower or harder. Thinking about this shift, what strikes you as the most critical consequence? Something to keep an eye on.